When an employee leaves a business, the company is likely to require that at a minimum, the departing employee not disparage the former employer. In turn, the employee may request that the company not disparage them either. This is called a non-disparagement clause. I'm Alex Rubin, owner of Rubin Employment Law. In this video, I'm going to explain what a non-disparagement clause is, why it's important to both employers and employees, and why such clauses may now be banned. Please keep in mind that this is general information, not legal advice, and the law may change at any time. A non-disparagement clause is often part of a severance agreement. It may be one form of what's called consideration for a severance payment. So, in exchange for receiving severance, a departing employee may be asked to agree not to disparage the company. The employee also may be asked to keep the terms of the severance agreement confidential. Note that another form of consideration for severance is usually the employee's agreement not to sue the company. Employees often ask that the non-disparagement clause be made mutual. That is, that it apply to the employee as well. Now, larger companies may restrict the non-disparagement clause with respect to the employee to only certain other employees, as it cannot control what everyone says about the departing employee. Enter the National Labor Relations Board. A recent decision by the board, which, by the way, applies to all employers, not just those with unionized employees, states that employers may not offer employees severance agreements that prohibit the employee from disclosing the terms of the agreement and from making statements that disparage the company. Why, you ask? Because prohibiting such statements could interfere with former employees' right to speak out about the terms and conditions of their employment with their former coworkers, their union if they have one, the National Labor Relations Board, the media, or anyone else. So, how does this ban on confidentiality and non-disparagement affect employers? It means that regardless of whether you offer departing employees severance, you cannot prohibit non-supervisory employees from disclosing the amount of severance or talking smack about your company. Note that you still can prohibit false, malicious, and reckless claims. This ban could hurt your company's ability to negotiate other severance packages and also hurt its reputation. How does this ban affect employees? You can collect severance in exchange for agreeing not to sue your former employer and still disclose the amount and talk smack about them. But you cannot ask your former employer or even certain people in the company not to talk smack about you. That could hurt your reputation just when you need to protect it most. So, what should you do in light of this ban on confidentiality and non-disparagement clauses? Well, if you're an employer for non-supervisory employees, you should remove the confidentiality clause and change the language in the non-disparagement clause to apply only to false, malicious, or reckless claims, and also state that it is not meant to interfere with the former employee's Section 7 rights. Now, if you're a departing non-supervisory employee, you should ask for a positive written reference from your employer. Look, these issues are nuanced, particularly when negotiating severance agreements. Both employers and employees are wise to seek an experienced employment attorney in their jurisdiction to help them implement the changes now required by this ruling and to negotiate any severance agreement. Whether you're an employer or an employee, we can help you get through this. Give us a call today.